Okay, this is VTL Quiz 2, which is all about 511's aggravated unlicensed operation of a motor vehicle. So 511.1 is aggravated unlicensed operation of a motor vehicle in the third degree. It is a misdemeanor, and the sentence of the court must be a fine not less than $200 nor more than $500, or a term of imprisonment of not more than 30 days, or both such fine and imprisonment. A 511.2 is aggravated unlicensed operation of a motor vehicle in the second degree. There are a few elements in which if you commit these, then the VTL 511 goes from third degree to a second degree. So the first is that the defendant has previously been convicted of an offense that consists of or includes the elements comprising the offense committed within the immediate preceding 18 months. The next is that the suspension or revocation is based upon a refusal to submit to a chemical test pursuant to section 1194 of this chapter, a finding of driving after having consumed alcohol in violation of 1192A of this chapter, or upon a conviction for a violation of any of the provisions of section 1192. The third is the suspension was a mandatory suspension pending prosecution of a charge of a violation of section 1192 of this chapter, ordered pursuant to paragraph E of subdivision 2 of section 1193 of this chapter or another similar statute. And the last element is such person has in effect 3 or more suspensions imposed on at least 3 separate dates for failure to answer, appear, or pay a fine. 511.2b, and this aggravated unlicensed operation of a motor vehicle in the second degree is a misdemeanor. If a person is convicted under subparagraph 1 of this section, which is having the prior 511 within 18 months, then the sentence must be a fine of not less than $500 and a term of imprisonment not to exceed 180 days, or where appropriate, probation or a term of imprisonment as a condition of probation. When a person is convicted of this crime under subparagraphs 2, 3, or 4, which is the DWIs or the 3 suspensions on 3 dates, the sentence of the court must be a fine of not less than $500 nor more than $1,000, and a term of imprisonment not less than 7 days nor more than 180 days, or where appropriate, probation or a term of imprisonment as a condition of probation. 4. 511.3. In order to be guilty of unlicensed operation of a motor vehicle in the first degree, based on the number of suspensions, the number of suspensions must be 10 on 10 separate days. 511.3b. Aggravated unlicensed operation of a motor vehicle, if for a 511.3, is a Class E felony. When a person is convicted of this crime, the sentence must be a fine in the amount not less than $500 nor more than $5,000, a term of imprisonment as provided in the penal law, which for an E felony says it shall not exceed 4 years, a sentence of probation, or a term of imprisonment as a condition of probation. 511A2. Facilitating aggravated unlicensed operation of a motor vehicle in the third degree is a traffic infraction. When a person is convicted thereof, the sentence of the court must be a fine not less than $200 nor more than $500, or a term of imprisonment of not more than 15 days or both. So this section you can be guilty even if you are not present, because you may have given somebody the keys to the car when you know that they are unlicensed. So you're facilitating their aggravated unlicensed operation. Okay, 511b. In all cases, a motor vehicle impounded pursuant to 511b shall be in the custody of the local authority and shall not be released unless 1. The person seeking to redeem the vehicle furnishes satisfactory evidence of registration and financial security, and the payment has been made for the reasonable cost of removal and storage of the motor vehicle. It also says in the statute that where the motor vehicle was operated by a person who at the time of the offense was the owner, you need satisfactory evidence that the registered owner or other person seeking to redeem the vehicle has a license or privilege to operate a motor vehicle in this state, and satisfactory evidence that the criminal action founded upon the charge of aggravated unlicensed operation of a motor vehicle has been terminated, and that any fine imposed as a result of a conviction thereon has been paid, or a certificate issued by the court in which the criminal action was commenced, ordering a release of the vehicle prior to the judgment or compliance therewith in the best interest of justice, or a certificate issued by the district attorney or other officer authorized to prosecute such charge, waiving the requirement that the vehicle be held as security for appearance before and compliance with the judgment of this court. Number 8, 511B7. A motor vehicle forfeited in accordance with 511B shall be and become the property of any local authority, subject, however, to any lien that was recorded prior to the seizure. Number 9, 511C3. Within 1 business day after a seizure of a motor vehicle pursuant to VTL 511C, notice of such violation and a copy of the violation shall be mailed to the owner of such vehicle at the address of such owner set forth in the records of the Department of Motor Vehicles. 511C. Inquiries into the facts of a vehicle seizure made pursuant to 511C shall be made by the Attorney General. If seizure by state police or by district attorney, unless the seizure is in the cities of New York, Yonkers, Rochester, or Buffalo. In those cities, inquiry shall be made by the Corp Counsel. Number 11, 511C. If pursuant to VTL 511C, there's a basis for the commencement and prosecution of a forfeiture proceeding, any such forfeiture shall be commenced in the Supreme Court not later than 20 days after the date of receipt of a written demand by a person claiming ownership of the motor vehicle. Number 12, 511C6. Where a demand for the return of a motor vehicle is not made within 90 days after the termination of the criminal proceeding founded upon the charge of aggravated unlicensed operation of a motor vehicle in the first degree, such motor vehicle shall be deemed abandoned. Okay, we skip to number 19. 511D. A person is guilty of the offense of aggravated failure to answer appearance tickets or pay fines imposed when such person has in effect 20 suspensions on at least 20 dates, and this is a misdemeanor offense.